Fudge, Ms. Boltinghouse, would you both raise your right hands and be sworn? Do you swear that the testimony you're about to give in this cause shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. You can put your hands down, and Mr. Feist, this is your motion. You may proceed.
Yes, thank you, Your Honor. Your Honor, we are here today to do a confirmation of arrears and a modification of a prior order. That was the final divorce decree signed in October 1st of 2023, where the child support was set at $1,625, medical support was at $25, and there was a spousal support of $2,000.
Okay. 10/1/23, is that correct?
No, it's 21. Sorry,
Okay.
Your Honor. Did I say 23? I'm sorry.
Okay. Okay.
And at this time, the spousal support was stopped on April 1st.
Okay.
Yeah. So there is no more spousal support, but there is arrears. So I'll go ahead and have Miss Boltinghouse call Miss Boltinghouse first.
Okay.
Miss Boltinghouse, what is your full name?
Jeannie Marie Boltinghouse.
And Miss Boltinghouse, what are the names of the two children in this case?
Jessica Pacey Fudge, Jonathan Purick Fudge.
And how old is Jessica?
Jessica just turned 18 in March.
And how old is Jonathan?
He'll be 15 next week.
Okay. And who do they live with right now?
Jonathan lives with me, and Jessica's belongings are here, but she is not physically here.
And where is Jessica right now?
Last I know is Frisco, Texas, in a mental health treatment center.
And
but they're by herself.
Okay. And how long has she been gone?
April 25th.
And are you in contact with her right now?
Off and on. She called me frantically high on the 14th of August, and that's what led me to know that she was in Dallas now rather than Austin. And then from there, I had the missing persons transferred from Austin to Dallas. And a week and a half later, so it would be the 22nd of August, Plano Police Department called me on the missing persons out of Austin, and I told them, no. Jessica called me and told me she was trafficked to Dallas while she was high on meth, and there's all kinds of trafficking reports and stuff through Dallas. Here's the report number, here's the case number, here's the detective's phone numbers, all three of them. And within 20 minutes, I had all three detectives calling me back that night, Thursday night, and they had her in Plano, Texas, Baylor Hospital being evaluated for her mental health. And they couldn't tell me after that, after they had left from interviewing her for being trafficked, they couldn't tell me whether she was admitted or not because the doctors didn't get there until 11 o'clock p.m. And even if so, they wouldn't be able to tell me she was admitted because she's 18. They were able to tell me that she wasn't pregnant. She wasn't high at the time of being picked up in Plano, or Plano, however it's pronounced. And that she was recommended for treatment. Don't know if she went until yesterday. I got HEB confirmation of 5 medicines being sent in. Well, there's only one person in this house that would need that many medicines. So I log in and check, and it said HEB Plano, Texas, with, of course, it has amounts next to them because she let her insurance expire. She can't pay for those. So I know she's not going to pick them up. Okay. Of course, I can pay for them online, but she's not going to take them. She's going to get rid of them so that she can buy drugs. All I'm trying to do is get her to a safe place. It doesn't have to be here at home. It can be wherever she wants to be. I just want her safe and healthy. That's all I want. I don't care if I get support for it or not. I just need an attorney and a judge to listen so I can get her done.
All right, guys. Today we are stepping straight into a courtroom where the stakes are already crystal clear.
Within seconds, the attorney lays out the financial backbone of this case: child support, medical obligations, and spousal payments, all tied to a past divorce decree. There's no build-up here, just immediate tension as numbers start defining the conflict. You can already sense this isn't just about money, but about responsibility and compliance. The calm delivery contrasts sharply with the weight of what's being discussed. Right from the start, the case positions itself as a financial dispute with deeper personal consequences waiting underneath.
Okay, Miss Boltinghouse, you're requesting indefinite support, is that correct?
Right. And that started in December because I knew she wasn't going to be able to do things on her own, which she's not. All she's doing is racking up ambulance bills for saving her life from ODing.
And could you explain to the court what is her medical condition?
She has bipolar, ADHD, severe anxiety, PMDD, and severe PTSD. And these were all diagnosed, except for the bipolar, before we adopted her. Bipolar was while we adopted her.
And did you, is there a medical doctor's report on that?
Yeah.
And did you
There's
send
many psychologists, psychiatrists, primary cares.
And you sent that in to the OAG and Miss Covis?
No, I sent it into the OAG. I have no contact with his attorney or him.
Okay. Okay, Miss Boltinghouse. I got information from Mr. Fudge's wages. And also, Your Honor, may I share my screen?
You may.
Okay, can you all see my screen?
Yeah.
Okay. So, Ms. Boltinghouse, as of August 31st of 2024, there is a child support arrearage of $12,426.94, a medical support arrearage of $496.46, and a spousal support arrearage of $60,973.94. Are these amounts, to the best of your knowledge, correct?
Yes, because I have the same chart you do.
Okay.
So, Roy, could you make that bigger? I can't see it.
Okay.
Okay. So you're asking for August 31st, is that right?
Yes, Your Honor.
$12,426.94.
Yes, Your Honor.
Thank you.
Okay, so these are, you hadn't received any payments that will change this amount, correct?
Well,
Besides what's on here already.
no, I haven't received anything else.
Okay. Your Honor, the state would offer this into evidence as what has been marked State Exhibit A.
Any objection, Ms. Cuevas?
No, ma'am. We agree with these figures. However, we'll be asking for some credits towards these figures when I put my case in chief on.
Okay, admitted?
Your Honor, may I stop sharing or you want me to leave it up here?
No, go ahead. You can stop sharing.
Okay. Okay, the on that child support arrearage, Ms. Boltington, the state's going to be requesting that the judgment be $12,426.94 with a repayment of $125 a month. Were you in agreement to that?
For the child support arrears?
Arrears, yes.
Okay. We need to talk about the medical first. because that's going to determine everything else being.
Right, that'll come next. Okay, so you're not in agreement to the $125?
No, because if the medical isn't put towards what you guys are trying to get it put towards, it needs to get put towards the rears of one of these.
We're getting there, Ms. Boltinghouse, okay?
Yes,
Bear
sir.
with me.
Yes, sir.
And the medical support arrearage is $496.46 with a repayment of $25 a month beginning October 1st. Were you in agreement to that?
I'm not understanding the medical part of it.
No, this is the arrears that Mr. Fudge owes to the state. Okay.
Yes, sir.
All right. Are you in agreement to that? That payback amount?
I don't understand why it's even being paid.
Hold on.
Jonathan is adopted. He's adopted through the state of Texas. His Medicaid is free. Just because we're divorced doesn't mean either one of us should have to pay medical for him unless it's out of pocket for, like, let's say his glasses that I pay for.
Because your divorce decree ordered it. That's why. At $25 per month.
Buckle up, guys, because now the situation starts unfolding beyond just numbers. The court moves from finances to family structure, revealing where the children are and who they live with. One child is present, but the other is physically missing, and that subtle shift instantly raises concern. The tone is still composed, but the details hint at instability behind the scenes. This is where the narrative begins to widen, from a legal issue into a personal crisis. It feels like the calm before something much heavier drops. The groundwork is being laid for a story that clearly goes beyond routine courtroom matters.
I can't answer why that's in the divorce decree. I wasn't there, but that's what your divorce decree requires. And therefore, the arrears are $496.46, which goes back to the state to reimburse them for a portion of the Medicaid. Now, we can talk about going forward, but
going forward, we know that it's not supposed to be like that.
We are only talking about going backwards right now.
Okay.
And your divorce decree ordered medical support, and that's where that $496 comes from. Do you understand? You don't have to.
I do understand. I'm not the one paying it. If he wants to pay that would be.
It's not up to him whether to pay it or not. It is a final judgment of the court. The court ordered $25 a month. It stands. No one can go back 3 years and undo an order from 3 years ago. That order stands until it is modified by the court.
Which we're going to do today as well?
We'll see. I haven't heard the information yet. Okay, go ahead, Roy.
And thank you, Your Honor. And, excuse me, the spousal support arrearage is $60,973.94, and the payment will be $100 a month beginning October 1st of 2024. Were you in agreement to that?
You told me it was $125.
No, that's the medical support.
No, that's
okay.
Oh, it's going to be child support.
Child support. So spousal support rears would be $100 a month.
Correct.
Okay. Upon discussing the $214 going towards medical, I can't, because that $214 needs to be placed on one of these other two.
We haven't gotten there yet.
Hold on, Roy.
Sorry.
You are talking about modification going forward. All we are talking about at the moment is the past due amounts and the money to be applied to those past due amounts. So the state is proposing $125 to the child support, which would come to you, $25 to the medical support, which would go to the state, and $100 on the spousal support, which would always also come to you. That is irrespective of the ongoing child support amount. Do you understand that?
Yes. And the 214 is for what?
I have no idea. I
Wait,
haven't seen that number
we're
yet.
getting to that, Miss Boltinghouse.
Okay.
That'll come next. we just need to cover the arrears first. Okay. Now we're going to move on to the child support and medical support. Okay. The modification. Yes,
Okay.
the modification. How is Jonathan covered for health insurance?
He has Medicaid through the state of Texas.
Okay. So, going over Mr. Fudge's finances, his wages.
Can I interrupt with one question real quick? Is
Yes,
Jonathan also adopted
Yes. They're
Through the-
brother and sister.
through the state?
Yes.
Thank you.
Okay, where was that?
You- sorry.
Using the calculation from his year-to-date wages, his gross monthly income was $4,760.83. Giving him credit for $214 for medical, the child support amount for one child would be $755 a month. Were you in agreement to that?
That's current. It's going
That's
to be
current. That's how much the state is requesting the court set.
For one
Again,
child,
that-
not two.
for one child. Now remember, the judge also mentioned to you, you don't have to agree to it. She's going to get all the facts and she'll decide that. Okay?
okay. Well, I don't agree to that.
All right. And the medical support will be set at $214 a month, reimbursed to the state. Were you in agreement with that?
No.
So what is the state's position on the fact that these parties were given free Medicaid when they adopted these children?
Well,
Now, years later, the state wants money?
Exactly.
the state got money through the divorce decree, Your Honor.
You what?
The state got money through the divorce decree.
Only $25.
Right. And the state would let the judge decide that.
You can urge it. I understand your position. Thank you.
You're welcome, Judge.
All right, guys, this is where the emotional weight hits hard. The mother reveals that her daughter isn't just away, she's in a mental health treatment center, and contact has been inconsistent. That single detail shifts everything from procedural to deeply personal. You can hear the uncertainty and tension building as the timeline of disappearance comes into focus. This is no longer just a custody or support case, it's about a vulnerable young adult in crisis. The courtroom energy subtly changes, and you can feel that everyone now understands the seriousness of what's unfolding. The stakes are no longer just legal, they're human.
I have no further questions for Ms. Boltinghouse, Your Honor.
Okay. Ms. Boltinghouse, at the end, I'm going to let Ms. Cuevas ask some questions of you. And then at the end, I'll come back since you're representing yourself and allow you to present anything else that you think you need to the court. Okay?
Okay.
Ms. Cuevas, do you have any questions for Ms.
I
Boltinghouse?
do, Your Honor. Ms. Boltinghouse, when I received the discovery packet that you sent to the Office of the Attorney General, there was several testing results and also testing results from the school. I did not see any medical testing. I saw educational testing extensively when the child was in secondary school, but there was no documentation from a medical provider that the child had seen, or her psychologist, or psychiatric testing.
Okay. I can't help what they chose to send to you, but I did send them everything. They got over 2,000 pages of medical
Okay, so
between the two kids.
just for the court, I did not receive 2,000 pages. What I did receive was I received all of the public school testing that the child went through when she was placed in the ARD and in that program. And I'm very familiar with that program, Judge. I'm sure you are too at this point. Just because a child is placed in ARD or she's deemed to have learning disabilities does not mean that she's medically incapable of caring for herself. And Ms. Boltinghouse, has her psychiatrist or her psychologist differentiated between her medical and her addiction issues?
Okay, she hasn't been seeing that I know of because she left here April 25th. She hasn't been seeing the doctors unless she admits herself into a facility. So,
Okay,
she's 18 now, and I can't get any access to any of that.
Okay, and I'm going to use some very antiquated terms, so please forgive me. But in the legal area that we're in now, it's called child emancipation. Back when I was in high school, they called it just good old-fashioned running away from home. Okay, and so I'm 65, and I guess I get to say that. But has the child stopped residing with you?
Yeah, she hasn't been in this home since the 25th of April.
Okay. And so do you anticipate her coming back?
I do. I don't know at what point she's going to hit rock bottom. She keeps getting the hospitals and ambulances this address for billing and residents. So I don't know what else to tell you. She hasn't physically been here since the 25th of April, but I have all of her bills from her trip away from home.
Okay. So the child support that you received this calendar year that is now just being modified, we filed to modify this child support back in May. So from January until today, you have received child support for this child. Is that correct?
Not for Jessica, no.
It should have by
Jessica stopped.
operation of law decreased to the 1,300. Roy, maybe you can put up the pay record again just to show that as of April 1, Ms. Cuevas.
Yes, right after her birthday.
Because the court had not ruled at that point on any indefinite support. So, yeah.
And this modification was filed in December, not whatever month you said, May.
Oh, no, I'm talking about my pleadings.
Well, actually, it was filed in March, Ms. Boltinghouse.
Yeah.
So in March 1, as you can see, well, you can't see me with my cursor. It's 1625. But then the very next month, April 1, it decreases to 1,300.
Okay, I did not see that on my copy, and I apologize for that, Judge. So, you're asking for continuing child support, even though the child is not residing with you, and some of the time, not maybe all of the time, but some of the time, you do not know where she's located.
She's located, it's all in the police reports. She's located at strangers' houses who will feed her addiction and keep her, have a place to lay her head at night. She's admitted to doing sexual favors.
Okay.
So no, they can't give me addresses of where they find her because she's 18. And on the police reports, they're going to be redacted because she's 18. I have submitted for unredacted reports, but I got to wait my 90 days for the attorney generals to approve or disapprove those.
Okay.
Well, she's only been gone 4 months, so 90 days. I got 6 or 7 police reports out for her. I'm still waiting.
There were some additional papers that you sent the Office of the Attorney General recently. Can you please tell me what those were?
It was a day and a half ago because I received my mail late in the day here, but what it is it's her ambulance bills from the day she left until the most recent one I got, I think was August 9th. It's from Uvalde, Austin, and Dallas. And it's almost $10,000 for life-saving measures from her overdosing.
And you may or may not be able to answer this question. So if you cannot answer it, I understand. Now that she has reached the majority age of 18, can she or could she apply for Social Security disability?
Buckle up, because this is where the story takes a shocking turn. The mother describes how her daughter allegedly ended up trafficked while under the influence, triggering police involvement across multiple cities. The level of detail, detectives, reports, hospital evaluation, adds intensity and urgency. This isn't speculation, it's presented as a chain of alarming events that unfolded rapidly. The courtroom is no longer just listening, they're absorbing a situation that borders on crisis intervention. It's chaotic, unsettling, and raises serious questions about safety and accountability. This moment completely transforms the case into something far more serious than anyone expected at the start.
Or do it.
Okay, thank you. I pass the witness.
Right, Mr. Feist? Or would you like Ms. Cuevas to call her client, let her do it, and then you can ask questions later? It doesn't matter to me.
We can let her go first, Your Honor.
Okay. I call my client Alan Fudge. Mr. Fudge, can you hear me?
Yes, ma'am.
Okay. And you were served with Office of the Attorney General papers, and this came after you had requested the Office of the Attorney General to reduce your child support. Is that correct?
Ma'am.
Yes? Yes
Yes.
or no?
Yes,
Okay.
ma'am.
And we actually filed that packet of papers that you were requested to fill out. In fact, you filled it out twice. Is that correct?
Yes, ma'am.
Okay. And we also filed a motion to reduce your child support. And why did we do that?
So I can afford to live.
Okay. So let's just take a couple of your paychecks that we've shared with Mr. Feist, for example. And so on one of your paychecks in May, you literally paid $1,900
Is there any dispute as to what his current wages are?
No, ma'am.
Okay.
No, ma'am. There's no dispute in that.
I don't know what his current wages are.
4,000.
I'm sorry. I thought she was shared that information, Your Honor.
$4,760.
That's correct.
Right.
And it vacillates somewhat. In May, it was $4,141.57. He works for United Rentals. Is that correct, Mr. Fudge?
Ma'am.
And sometimes you have a little bit of overtime and sometimes you don't. Is that correct?
Yes, ma'am.
And for example, in May of your paycheck for that month, you paid $1,932.58. Is that correct?
Ma'am.
And that was in general support. Isn't it true that United Rentals does not break down each of the support allocations? Is that correct?
Ma'am.
And we shared that with Mr. Feist. Is that correct?
Yes, ma'am.
And so you have been paying at least 50% of your paycheck stubs every month to pay off not only the arrears, but also to pay the current balances as well. Is that correct?
Ma'am.
And how long have you worked for United Rentals?
almost a year and a half.
Okay. And so this has been very consistent and reliable income for you. Is that correct?
Yes, ma'am.
And so as of today, we're asking for the court to modify your child support for one child, your current child support for one child at $755.33. Is that correct?
Yes, ma'am.
Now, the Office of the Attorney General previously, without us knowing about Ms. Boltinghouse's objections of payment for medical support, they had wanted you to pay over $400 in medical support for the one child. Is that correct?
Ma'am.
And so we requested, instead of 9%, that be paid at 4.5%, which is $214 a month. Is that correct?
Yes, ma'am.
Now, if the court were to waive that $214 for medical support, then you would be able to take that $214 and place it in other areas so that you could address the arrearages that we have. Is that correct?
Yes, ma'am.
So in December of 2023, you sent in your initial packet to reduce your child support. Is that correct?
Yes, ma'am.
And then on May 15th, we filed your packet that you filled out, plus a motion to modify and ask for credits based on your attempt to reduce your child support as far back as December. Is that correct?
Yes, ma'am.
So, but by statute, you're actually allowed to have a reduction in child support. Go back to the date that we filed the documents, which is May 15th of this year. Is that correct?
Yes, ma'am.
No, ma'am.
And so,
Correct. It's March 22nd, this was filed. This is eligible for a modification up or down based on the Attorney General's pleadings. They plead for a modification. No, they don't plead for an upward mod or a downward mod. Therefore, this case is eligible for a modification beginning April 1 of 2024.
okay, I misunderstood then because I thought it was based on my modification that I filed in May. Okay, so I stand corrected. Thank you for correcting me. But we know for a fact that child support for one child is $755.33, and you're accepting that figure. Is that correct?
Ma'am.
And with the extra money that you have freed up in overpayments, you're actually going to allocate $125 to back child support, correct?
Yes, ma'am.
$100 in spousal maintenance, is that correct?
Ma'am.
And $25 in medical support arrears, is that correct?
Yes, ma'am.
Okay, if the judge does see fit to waive that $214, can you tell the judge where you would like that money to go?
Yes, ma'am.
Where would you like it to be applied?
To the rears. As far as
Okay,
All right, guys, now the raw emotion starts pouring out. The mother shifts from recounting events to expressing fear, frustration, and desperation about her daughter's condition. She talks about medications, addiction concerns, and the constant risk of relapse, painting a picture of someone barely holding things together. This isn't structured testimony, it feels personal and urgent. Her words reflect a parent trying to regain control in a situation that's slipping away. The courtroom becomes a space where legal arguments blur with emotional reality. You can sense that for her, this isn't about winning, it's about saving her child.
the child,
so would you like it to go to the maintenance arrears for the spousal support, or the child support?
The maintenance for spouse.
Okay. So you understand that Mrs. Beltinghouse is requesting child support for 2 children, not 1 child.
Yes, ma'am.
And have you personally been given any information regarding your daughter?
No, ma'am.
Other than what you have seen on Facebook and people's statements, do you believe that your child has any intention of coming home to her mother's house?
No.
Okay. Your Honor, I pass the witness.
Mr. Feist, do you have anything else?
Yes, Your Honor. Mr. Fudge, how long did you live with the children?
From 2015 to 2021.
And how often did you visit the children?
I did it when I had a schedule to where I was 4 days on, 4 days off. So I didn't get them every weekend. I got them whenever I was off. And every time I was off, I had them.
Okay, and how often did you see the children? To the best of your recollection.
Let's see. I quit seeing them in December of 22. Probably
December of 2021.
Probably 3 or 4 times a month.
So 3 or 4 times a month.
Yes, sir. 'Cause-
Currently also?
No, sir. I hadn't seen them since December of 21.
Okay. I have no further questions for Mr. Fudge, Your Honor.
Okay.
I have nothing further, Judge.
Okay. Ms. Boltinghouse, I'll let you, since you're representing yourself, make a brief closing statement. Or basically just tell me anything else that you think the court needs to know.
Okay, if he's been at that job for 1.5 years, why were there missed payments?
I don't know. This is your chance to
I'm looking at the same papers y'all are, but I'm going back and looking
okay.
at 1.5 years worth.
This is your time to tell me anything else that you think I need to know. So maybe if you want me to look at missed payments, I can do that, although I'm not sure it's going to affect the bottom line of what's owed.
Okay, well, let me tell you this. No, he has not had contact with them since, I believe it was December 9th of 2021.
Okay.
There were allegations made.
Okay.
And there were, CPS determined it was, can't think of the wording. They believed the allegations against him. So they have it on file. They have him on record that he's not allowed to.
And how does that affect what we're doing today?
Neither one of the kids want to be around him.
Visitation is not an issue today. So,
okay. Now, Jessica coming back home, referring to that, she told the detective, and I know y'all don't have access to this, and I don't have access to it yet either in writing because I'm waiting for it. She told the detective that she wants to come home and get the help she needs. She's ashamed of the things that she's admitted doing. So she's afraid of what we're going to think. And he's supposed to tell her back if she calls because he gave her his card, to get more help, but she has to call when she got out of wherever she was at. So she would have called maybe yesterday or today if she wants the help, because he can get her into all kinds of shelters and facilities and medical and all that stuff. But he's supposed to tell her that we don't care what she's done. We just want her safe. So she wants to come back home because she's calling me, telling me that people have threatened her and threatened us, and she called me drugged up, worried that something was going to happen to us, and she just wanted to warn us, and she's sorry for the things she's done. I can't tell her that because she don't have a phone. I don't have her on Facebook. The people that do have her on Facebook tells me that she hasn't made a post in over 2 months. She's just traveling lost. And the only way I can help her is getting someone to help me get access to her, at least a medical power of attorney. But nobody will do that for me here. I spoke to the judge, directly to the judge. Nobody would do that without her being present.
Well, and I'll comment on that in a minute when I make a final ruling.
But, I mean, she, right now, in her mind, she doesn't want to go home because she's ashamed, but there's no other reason for it.
For today, let's talk about what we're going to do, and
buckle up, because the case now pivots sharply into legal territory. After the emotional testimony, the focus turns to whether support can continue beyond the child turning 18. The law is laid out clearly, emphasizing conditions tied to disability and ongoing care. This is where emotion meets legal standards, and not everything said earlier will automatically hold weight here. The mother pushes for indefinite support, but now she has to justify it within strict legal boundaries. It's a crucial turning point where sympathy alone isn't enough. The courtroom shifts from listening to evaluating, and the tension becomes more technical and precise.
Tell you some things. Let me start with, I'm going to take my judge hat off for just a second, and I'm going to talk to you with my mother's hat on. I have a stepdaughter. Been there. It is very, very difficult. Once they're 18, they get to make the decisions. And I'll be honest with you, I haven't heard anything today. I do not think addiction has reached the level of requiring indefinite support, because you can't even, she's of the age where you can't do anything without her permission and or getting an involuntary commitment, but kind of have to find her and locate her and keep her present for that. And it is extremely difficult. I will also tell you that Social Security disability does not look kindly on what they consider voluntary disabilities for the purpose of long-term disability. Drug addiction, alcohol addiction, it's very, very difficult to get disability, unfortunately, until they have reached the point that their body is not functioning. And then it seems like Social Security disability is a little more reticent. Although, quite frankly, I wonder if she's even qualified because she hasn't worked to pay into Social Security. But that's my mom hat, okay? I do wish you well. I know that road. I will tell you that sometimes that road has a nice, I won't say a nice ending because we're not clearly at the end, but sometimes that road does get better. And sometimes it doesn't. But for you can keep trying and keep, if you're a kind of person who praying for your daughter, but you cannot control it. Okay. I am not ordering, I am not ordering indefinite support. So, I am going to disagree with the state, and you guys were given free Medicaid, despite the fact that your divorce says differently. I'm not sure why. So I'm going to set medical support at 0. Because that was something she was given, you were given for both of the children when you adopted them. So I'm not going to make you, Mr. Fudge, I'm not going to make you repay anything to the state. Now, what that does is that adds that back into my calculations, and I come up with $800 a month in child support. And that will begin, Mr. Fudge, you were served April 12th. That will begin May 1st of 2024. You will not get any money back. I need you to understand that. It's already been distributed to Ms. Fudge. It will be reallocated a bit to be applied to your arrears. I'm also going to change the amount that of your repayment. The $125 on the child support arrears will stand. That begins September 1. The $25 a month on the medical also stands. That will begin. But I'm going to bump your spousal support to $200 a month.
Okay, that's fine, Judge. I mean, I spoke to him literally about keeping the money in the pot. We just needed to find out what was a good allocation.
Well, and honestly, that's already been paid out. So there's not recouping that when you have especially substantial arrears. And so it will be reallocated in whatever way the state does that. Quite frankly, they may wipe out their own medical arrears because they do things like that. That's not within my control, how they reallocate what they've already gotten. Going forward, it will be $125 on the child support, $25 on the medical, and $200 on the spousal.
All right, guys, now comes the financial reality check. The exact arrears are presented, and the numbers hit hard. Tens of thousands in unpaid obligations. There's a brief moment of agreement, but it feels more strategic than cooperative. The opposing side signals they'll seek credits, hinting that this isn't settled yet. The calm exchange masks underlying tension about who owes what and why. This is where the financial consequences of past decisions fully surface. The courtroom energy tightens again, as these figures aren't just numbers. They represent years of unresolved responsibility now being brought front and center.
Okay.
Which means, Miss Boltinghouse, you will be receiving $1,125 per month. So it's not much of a change for you.
But it's a huge change for my client, Your Honor.
Right, absolutely.
And thank you.
And
thank you.
The other thing is, Mr. Fudge, you'll need to understand that once Jonathan turns 18, that $800 will be, and Roy, you probably should put this in since I'm going to order that it be bifurcated. Of the $800, $400 a month you'll continue paying what you pay. Okay, you will continue paying $1,150 a month. The $25 a month may go away at some point. That's your medical arrears. Once Jonathan turns 18 or emancipates by graduating, the $800 that you're paying for him, you'll keep paying, but it will be added to the child support arrears, and added $400 will go to the child support arrears. So that number will become $525, and $400 will go to the spousal support. So that number becomes $600. So you just keep paying what you're paying for a while.
Buckle up, because the case closes on a critical challenge that could reshape everything. The opposing attorney questions the lack of concrete medical evidence, pointing out that educational records don't prove incapacity. This is a direct hit to the foundation of the mother's argument for extended support. It's no longer about what's been said, it's about what can actually be proven. The tone becomes sharper, more confrontational, and highly strategic. This moment puts credibility on trial, not just claims. As it stands, the outcome now depends less on emotion and more on documented proof, and that changes everything.